translation.
Немає перекладу. Так? Ще раз, будь ласка.
Once again. Let's try once again.
Є?
Now there is translation. Thank you. Let's continue. John J. O'Sullivan and Jessica Lott Thompson. Also, there are present members of the High Qualification Commission of Judges, Mr. Bogunis, Volkova, Yaroslav Druh, Nadia Kobetska, Oleg Kolush. Ihor Kushnir was somewhere. He will come. Alexei Omelian, Roman Sobadash, Ruslan Sorovich, and other members of the Qualification Commission will join us later. I am the chairman, deputy head of the commission, Oleg Kolush. There is the secretary, Elena Lopushniak. The quorum is here. The special High Qualification Commission of Judges and Public Council of International Experts meeting is declared open. I'm informing you that we have live broadcasting and the correspondence of the candidates to the criteria provided for by the Part 4 Article 8 is established according to the published list. The first will be Omelian Ihor, the first candidate, the second candidate Kitsuk Victoria, and the third candidate Dubas Vitaly. About Kitsuk Victoria Sergeyevna, the reporter will be absent. I suggest we change the order of the second and the third candidates. Who's for? Unanimously, so the list of questions submitted for examination looks as follows. The first candidate will be Omelian Ihor, the second candidate Dubas Vitaly Mikhailovich, and the third candidate will be Kitsuk Victoria Sergeyevna. I would like the secretary to inform us about the presence. The invited candidates to the position of judges of the High Anti-Corruption Court came, specifically Omelian Ihor Volodymyrovych, Kitsuk Victoria Sergeyevna, Dubas Vitaly Mikhailovich. Please invite the candidate Omelian Ihor Volodymyrovych to the hall.
Добрий день, сідайте, будь ласка.
Good morning. Please take your seat. We will consider the correspondence of the candidate Omelian Ihor to the criteria provided for by the law of Ukraine on High Anti-Corruption Court. In the whole, there are members of the Public Council of International Experts, offline and online. Also, there are present the High Qualification Commission of Judges members, Людмила Волкова, Yaroslav Druh, Nadia Kobetska, Oleg Kolush, Ihor Kushnir, Alexei Omelian, Roman Sobadash, Ruslan Sorovich. Do you understand the composition of the commission? Yes, I do. Please be informed of your rights. You have a right to recuse the members of the commission, also file a petition, express your considerations, and contest the issues that are being considered. We do not consider any new materials that the candidate submits if previously the candidate could submit these documents, but they were not submitted to the commission. If there are any circumstances that can affect your decision or the initiative of at least 3 members of the commission, the decision might be adopted to accept additional members if the decision is voted for by at least 3 members. Do you understand your rights? Yes. Are there any recusals or petitions? No recusals. I would like to inform in advance to avoid any misunderstandings later that Roman Yurievich is friends with me on Facebook for some time. Who is Roman Roman Sabadash?
Зрозуміло.
Bogdanovich. All right, before there are no grounds because you gave a different patronymic. So what? Nothing else.
Колеги, з цього приводу не буде запитань.
Clear. Are there any questions about it? No.
Протоколу повідомляю, що до засідання
I should inform that Commission member Vitaly Gateluk joined the meeting. The rapporteur on you will be Sabodash Roman Bogdanovich, so please, the floor is yours. And we were friends for some time on Facebook. Right, dear colleagues, good morning once again. So, by the decision of the High Qualification Commission of Judges, this competitive selection was announced. Omelian Ihor applied. Roman Bogdanovich, Chumak Serhiy Yuryevich joined the meeting. Thank you. Ihor Volodymyrovych Omelian applied for the competitive selection and he was admitted to qualification assessment. Then the general results of the first stage were announced. The candidate scored 337.4. And he was admitted to the next stage, the interview. So Omelian Ihor Volodymyrovych, at the moment of applying, was 49 years old. He is a citizen of Ukraine, graduated from Khmelnytsky Institute of Management and Law, and quite a qualification lawyer specialist. The information about scientific grade is absent. He was a senior legal counselor in Rechensky Enterprise. He also worked in Turhovich in Podillia. Until 2018, he acted as a counselor, and he has been a self-employed lawyer. He also was a legal counselor and leading legal counselor, deputy director in the Interregional Academy of Personnel Management till 2009, head of legal department, director of legal department of the First Realtor Group Corporation, later Deputy General Director of Legal Affairs, LLC Barclay in Ukraine, Director of Legal Department, Deputy Head of the Board of Legal Support, First Realtor Group Corporation. Also, he was a managing partner in 2020-2024 of the Law Bureau Omelian Lawyers. Also, the candidate has an experience of leading a number of legal entities, and since 2024, he is a professor in the American University and European University, and he was issued a attorney license by the decision of QDBC since November 2022. A disciplinary complaint was submitted against him, but it happened by a different party about the actions of the lawyer. We will talk about it. In 1999, he became member of the Social Democratic Party of Ukraine. He didn't participate in its activities, and as he moved to Kiev, he didn't maintain any relations. In March 2025, to comply with all the conditions as to non-membership in the party, he sent the request to cease his membership It stems from the explanations of the candidate. He participates in the selection to the position of the local court judge, and he was admitted to the fourth stage of qualification examination, a practical test, and that's a brief intervention about the candidate. If there are any questions, please. Thank you, Bogdan, and I'm passing the floor to the head of the Public Council of International Experts, Mr. Robert Kansen, please. Did you want to say something? Excuse me. Yes, please. Since the 1st of August last year, I changed my place of employment, the college, pharmaceutical college. Okay, we will take this into account, please.
Okay, thank you. Good morning, Mr. Omelian. I pass the floor to my dear colleague Norman Aas, who's sitting next to me, and he will be the rapporteur in your file.
Thank you. Good morning, Mr. Omelian. My name is Norman Aas. I'm from Estonia. I'm an attorney and I'm a former prosecutor. And as already mentioned, I'm your rapporteur. And thank you for participation in that competition for hard charge. It's a very important position. And also congratulations already reaching this joint meeting phase of the proceeding. And thank you all those answers and documents already shared with us during written question and answer rounds. But as this is public interview and the broadcast online, I question again some of the topics as to in the interest of transparency. And I'd like to start with your previous experience in criminal legal field, and we know that you are attorney already many years. And can you briefly describe what categories of cases you have handled throughout your career as attorney, and please provide some sort of approximate breakdown between the civil cases, criminal cases, administrative and commercial cases, just to have a better understanding about your expertise in this field.
Дякую за питання.
Thank you for the question.
У мене переважно був досвід ведення
My expertise is mostly in civil and commercial cases.
Вирішення питань щодо поділу майна.
It was related to separation of property. It was related also
цього права.
To the content. It's hard for me to say what was the ratio approximate among these categories. I also have an experience in handling criminal cases, but it's not too extensive experience. I could recall the cases that I participated in as a legal counselor. So these were 4 cases under Article 336, then Part 5 of Article 19N, appropriation of someone else's property committed by an official. So it's a case related to what the anti-corruption court is doing. Also, there was a case according to Article 185 breaking and entering, Article 187, illegal appropriation of a vehicle and violence dangerous for life, and Article 155, rape. Also, I represented the interests of clients as part of proceedings as an attorney for witnesses during interrogation, and also as a representative of a claimant who was a victim. Why do I consider my experience relevant and one that can be used within the HACC? In my opinion, it corresponds to the tasks that the HACC sets. It ensures proceedings in criminal, administrative, and cases related to applying sanctions, and in civil proceedings related to the unlawfully acquired assets. And when it comes to the unlawfully acquired assets, I probably have the biggest experience among all the participants of this selection. And I think this experience will be useful. As far as I know and understand, some judges need to learn things from scratch as they apply for such a position. And for me, I am used to handling such cases over the years. I also had administrative cases against state authorities, and it can be compared to what the HACC does when it applies sanctions. So it will not be something new for me that I will have to learn from scratch once again. I don't have a very rich experience in criminal cases, but probably that's my advantage, since I'm not. I don't have any ties. I don't have any commitments, corporate commitments. I don't have any links or ties that might constitute conflict of interest in considering similar cases. So the content.
Quite short of time, so please be so concise as you can.
Basically, I've explained my position. Excuse me, I would like to inform that Tomasiuk, commission member, joined us.
Thank you. You mentioned some of the articles in Ukrainian criminal code. I'm not so familiar of that, so this is just a clarifying question. Do you have any practical experience handling corruption-related cases before the High Anti-Corruption Court? Have you represented any clients before this High Anti-Corruption Court?
No, I don't have any experience of presenting clients, defending clients in the Anti-Corruption Court. As to handling corruption cases in general, yes, the Article 191 is one related to corruption offenses.
Thank you. I like to go further to other topic. According to the document provided or shared with us, we know that you served as director of many companies 2020 to 2021, for example, Woodpecker Consulting, Their Consulting, Crest Consulting, Clerici Consulting, Links Consulting, and Victor FTV LLC. And you your written responses, you indicated that you had this was part of your legal services as attorney, but you had full powers as director, including authority to open bank accounts, sign all the documents, and so on. But at the same time, you explained that by agreement with the founders of those companies, bank accounts were not opened for those companies. So please, how do you explain the founding of companies that operate without bank accounts?
Період невідкривання банківських рахунків був дуже
The period when the bank account were not opened was very brief. It was around 3 months, and there was no need to open bank accounts.
вирішував певну
That's why
проблему з небезпекою, яка може виникнути.
that's how I prevented the problems that could appear.
Вирішувались всі питання.
So we've handled all the problems when the salaries had to be paid through the
Після того, як була передача, зміна директора,
through the
починали
cash desk of the enterprise, and the enterprises practiced commercial activities. At the stage of establishment of the enterprises and at the stage of getting all the licenses and permissions, there was no need to open any bank accounts.
But it doesn't mean that the companies operate exclusively in cash then.
Ні. Я
No. Would like to draw your attention to the fact that we did not have any transactions in cash. We only paid salaries in cash to our employees, and that is allowed by the law. So the current law previews that salaries can be paid through the cashier desk or through the current account. In order to make it possible through a cashier desk, the founder submitted the necessary sum, including or extracting the taxes, and then there was no need to turn to banks for incassation, and I submitted all the documents proving that, and this is how we paid salaries to our employees according to the law.
Thank you. You also indicated that yourself received a salary from those companies as a director, and understood I correctly that your salary was also paid to you in cash.
Зарплати – це і є виключна зарплата найманого.
True. We are talking about salaries for employee salaries. And I was an employee. I was a hired director. And the cash that the founder submitted was used to pay salaries for all the employees. And this is legal. This is lawful.
Including you get paid in cash. That's what's the question.
Я звертаю увагу не в тому числі, а виключно я.
Exclusively me, I got my salary in cash. Only myself.
You mentioned the cashier. You as director of those companies, were you responsible for maintaining those companies' cash register or cash
Так, і касові ордери
Yes.
виписувались, складалися, касова
And,
книга, все це було.
cashier orders and all of that was governed by myself, and I submitted all those documents to the new director when I dismissed from my position.
And understood correctly that the founders of those companies, they paid cash into cash register. From where the cash was transferred to cash register? Who paid that?
Ніякого готівкового реєстру не існує.
There's no cash register. There's a cashier cash register. Each legal entity has it, and there is also cash book, and when someone gets a salary, they also get a receipt. I would like to draw Norman's attention and all of the commission members' attention to the fact that it was done in order to comply with the law. A legal entity needs to have a hired director on salary. It was not done in order to hide profits from the tax services, because even judging from the sums that were received, they are symbolic, or 270 hryvnia per month. So I would like you to have the right impression and not think that this was tax evasion.
Thank you. Of course, I'm foreign and I'm not expert of Ukrainian law, but yes, I believe you that this was in line with Ukrainian law. But I'm interested in just in the facts. So, and my question was, who paid the money into cashiers of those companies? Because from somewhere the money should originate. So who paid the cash to the cash cashier to pay out all the salaries and taxes?
Ніяких касирів не було.
There were no cashiers, booking clerks. I was the only person that was a staff member, hired employee in this enterprises. What happened after me, I don't know. Bank tellers. So the founder paid for the bank service related to this.
My question was,
I can explain.
During those 2 years, you get paid as a director and you get the salaries in cash. And my question is, who paid this cash to the cash register? Nobody.
Нет. Пан Норман, не 2 років, а 3 місяців.
We're not talking about 2 years, we're talking about 3 months. No more than 3 months in each enterprise. The founder paid the money to the cashier desk, the cash register. And this duty can be done either by an accountant or the director. Because there was no other employee able to do that, I was the one doing this, the director. So let's say I bring 300. First, participant brings 300 hryvnia, all the taxes are paid, and then the rest is submitted to the cash register, and then the salaries are paid. At the age of creation of a LLC, we don't have membership fees until we really start making profit.
Okay, so the founders of those companies paid cash into cash registers, and from this cash register, you get paid as salary. Okay.
Да, я зверну увагу, що ця готівка була
Yes,
в межах
that cash was within the limit of the statutory capital of the company. And that capital needed to be established within the first months of the establishment of the company. And that money wasn't a profit for that legal entity, because that is statutory capital that covers the current expenses of the enterprise.
Thank you. Let's move next. I have questions about two companies. And the first company name is Podil Agro Investment LLC. This company was registered in December 2016 with a share capital of 4,200,000,000 hryvnias. This is quite a big amount. And most of that word was indicated as intellectual property, specifically rights to use some sort of know-how. And your share in this company was 1/3, 33%, also almost 1.4 billion hryvnias. And another company, this is English name Marine Investment Group LLC, was also registered 2016 in November with a share capital of 560 million hryvnias. And your share in the company was 24%, approximately 140 million hryvnias. And you have explained that most of the value of the share was know-how. Please, can you describe the content, scope, and this economic model of using this know-how? What was so worth for the companies more than billions hryvnias?
Це зовсім інша історія.
Well, this is a different story.
Інноваційність цих проєктів полягала в тому, що
So the know-how in those projects was that each of those projects, if implemented, could bring the results intended for these companies in the cost estimates. It was about construction of a terminal in deep sea in the Black Sea. And the other one is using big agro-industrial complexes to grow produce for export, and using that deep sea terminal in order to carry out export agricultural produce. So the know-how was that until that time, no one else built that type of terminal. The first time they tried to do it in 2010 at the public level. They raised money from the state budget, but to my knowledge, within 15 years, nothing good came out of it. And our LLC proposed that we do that with the help of private capital, private equity, with a much smaller budget, but because of the circumstances that I have already mentioned, that also failed as a project.
As you mentioned, most of that investment was made in the form of know-how. But can you recall your investment in those companies was also only in the form of know-how, or you invested some real money to those companies as well?
No, I have submitted explanations and documents, the receipt, notes, the evaluations of the statutory capital done according to the law by the participants, shareholders, and we haven't progressed further after that.
And understood I correctly that the value of this know-how, this was only assessed by the founders, not some sort of impartial valuation wasn't carried out before to put this amount in the balance sheet of the companies.
Well, because this project is highly specific and know-how as intellectual property is very specific, it doesn't involve third parties reviewing it. Then the law on LLCs, Article 13, says that evaluation is done by the founders without third parties involved. In case that was public property or part of it was in communal property, public property, then third parties would be involved.
On the very end of last year, in December 2025, you were excluded from the shareholder of the both companies, and the share capital was reduced by the amount of your share, respectively. But my question is, did you receive any compensations for the value of your shares? Any money, any property, or property right, IP rights, or nothing?
Well, I was excluded on my own wish. I submitted an application back then, and in my application I stated that I bore no grievances. I also explained explanations, and I didn't get any compensation for my share.
According to the open sources, both of those companies are mentioned in one criminal proceeding, what we have indicated already in the written questions round. And both of those companies are suspected as taking part of one fraudulent scheme and a money laundering scheme. So how you can comment that?
From what I found in the register of court decisions, neither company is suspected in fraudulent schemes. In court decisions, they say that the costs obtained were used in commercial activities of those companies, and I doubt the veracity and reliability of the information indicated in the court decisions of the investigating judges. In the motivation part section, It says that criminal cases were opened in early 2016, and actually that is before the LLCs are registered. So criminal case arised before the suspect came to being. Then information on commercial activities come from the director, and LLCs didn't even have time to open bank accounts because the national police extracted all the documentation from them. And then the police said that they never got them, or then that they lost it. And then the director asked the national police to return at least some documents. And until now, these cases have not resulted in any good. And these are just bare words. And I don't know what happens to these criminal cases now. I know that there were requests done to the national police to return the documents, but no answers were received.
When you learned first time about these criminal investigations, where at least the names of those two companies were mentioned?
Well, as I wrote in early October 2019.
Let's move on. According to your declarations, you declared 3 real estate objects in Kiev, acquired in 2017, 2 apartments and 1 parking space. And you explained that these real estates belonged to father who died, and after death of your father, you inherit those real estates. Can you assess the value of those real estates, 2 apartments and 1 parking slot? It wasn't indicated in your declaration.
Не зовсім так, чи навпаки не так. Я зазначив 4 об'єкти
I indicated 4 real estate objects in my declaration.
нерухомості, які, якщо б я
One object, if I hadn't registered it, no one would ever know about it. So one bedroom flat, 2 apartments in new buildings that I inherited from my father, and in that same residential complex, a parking lot. And so these are 4 real estate objects, and I declared them all in my declaration.
В продовження вашого питання щодо цінності,
And to continue regarding the value of those real estate objects. First, 1 bedroom flat is in an old building, and I don't remember its value. I haven't studied this issue. Then 2 apartments in a new building, residential complex, they are more expensive because that residential complex is 12 years old, rather new. I don't know the value of the objects because I inherited them. And because it was my father, evaluation wasn't done, and such duties do not arise to evaluate the real estate objects.
Do you still have those 2 apartments origin from your father?
За адресою Гетьмана, вулиця Гетьмана, 2 квартири.
Hetmana, the address is Hetmana, 2 apartments and a parking lot. This is what I inherited from my father.
But do you still have at the moment those apartments, or you have sold?
Ні, досі я на них маю право власності. Я в них
I'm still the owner. I still have them and I live in them. Those 2 apartments, they are 2 apartments legally speaking, but in fact this is 1 apartment.
Фактично це одна квартира з одним
So,
входом.
in fact, this is just 1 apartment with 1 entrance.
And who is using at the moment those or this big apartment then? Who is living there at the moment?
Я та моя дружина.
Myself and my wife.
The next topic. From December 2020 to May 2024, you were a managing partner at the law firm Omelian Lawyers. At that time, did you provide your legal services only through this law firm?
Я прошу повторити питання, тому що або воно некоректно перекладено, або не...
Could you repeat the question? Because there is some incorrect facts. I don't understand it.
According to the declarations from December 2020 to May 2024, you were a managing partner at the law firm Omelian Lawyers. Is that correct?
Так.
Yes.
And my question is, during that period, did you provide legal services as attorney only through this law firm? Were your clients the clients of that law firm?
Справа в тому, від Omelian Lawyers, я не можу надавати сам своїй фірмі послуги.
I cannot provide services to my own firm. I am the managing partner, and I am providing services on its behalf. And from 2020 to 2024, I have been the managing partner.
How many attorneys were in your law firm? Only you, or?
До повномасштабного вторгнення.
Before the full-scale invasion, just one. Just one on top of myself.
It means 2 together.
Yes.
And was this your full-time job at that time?
Для обох це було робота за основним місцем роботи.
It was full-time job, but for my employee, an attorney, we had agreed, because she also had a law firm of her own, we had agreed that she could provide attorney services to third parties. So it was on one hand full-time job, on the other hand, following an agreement with me, she could leave her office and take part in other legal proceedings where she defended and represented her clients.
Did you receive any salary from your law firm during that period, or income in the form of dividends, for example?
Від своєї компанії.
From my own firm, yes, I got a salary, and on a regular basis before the full-scale invasion, and after that there was a break because, in fact, we had no work, no cases, no clients, and I didn't pay dividends. And depending on the outcome of this competition, I will decide on the destiny of the costs belonging to my firm. That can be done at any moment.
End of 2024, you declared that your law firm has loaned to you amount of 454,000 hryvnias. Understood correctly that your law firm gave a credit to you, not a salary, not the dividends, but this almost 500,000 hryvnias was given to you as the loan.
Yes.
And what was the reason for that loan? Respectively, there were enough cash in or money in the company, in your law firm, to pay the salary or to pay this money as a dividends. But why you chosen to take out this money as a loan?
I
tried to explain it in my written explanations. My logic is very simple. I believe that my company will continue its activities, so we will need funds for that. And for the office and for paying the salaries. So I made the decision not to leave funds in the company if I need to then add it to the charter capital to increase it. So I still have certain obligations. I could not declare it, and the Commission wouldn't know about these funds, not the Commission or an external observer. So it was my own initiative to show it. That's my second point. And third, what were my considerations? It was not a one-time payment. It happened through several stages. I could see the dynamics that the National Bank starts to announce banks, Ukrainian banks, one after another, and as bankrupt. And I realized that it's a problem of our market due to objective reasons. And if the funds remained at the current account of the legal entity, there was a probability that these funds would be lost because the funds of a legal entity actually, in case of a bank's bankruptcy, the needs of legal entities are not priority of banks, and the funds of an individual at the beginning of the martial law and within 33 months after the martial law is lifted are repaid by the fund in full. So when I accrued this loan to myself, why am I saying I accrued? Because the law firm is basically me. I accrued the loan to myself, and I used a certain part because I needed money for the current needs, for treatment, and the rest, which was temporarily free, I placed as a deposit. That's how I protected my funds from the devaluation and from losing it. It was an economically responsible, economically reasoned act. It's not because I wanted to evade taxes. these funds that are reflected were after the taxes were paid, so it wasn't the income after the taxes, but before the taxes were paid by the individual.
Thank you. Was a written agreement concluded to lend this money to you from your company?
Yes, before every payment, a written agreement was concluded indicating the bank details in every agreement, and everything is reflected in the financial documents, and the copies of the agreements were provided upon the request of the PCIe.
Was any interest also agreed? Usually the loans are related to some sort of interest.
No, since the Bureau is not a loan institution, it cannot get interests. Moreover, I didn't think it was necessary to increase my own risks by establishing an interest. I, as a director, as a founder of the Bureau, could decide on the way the property of this Bureau and the income could be managed. So I decided on the conditions of the loan.
And was any repayment date agreed in those contracts or not?
I indicated as soon as the circumstances would appear, that circumstances that would allow to restore activities. So I set myself the requirement to return the loan. To avoid any misunderstanding, there were no other person whose interests could be affected by this loan. I was the one requiring the repayment of the loan, so as soon as the requirement appears, I had to return the funds.
And this requirement to return the money, it's up to you as well. This is ultimately up to you when this money will be repaid, because you are also a representative of your law firm who can reclaim this money back, or I'm wrong?
Yes, that's right. I am the one deciding everything within this law firm. That's according to the legislation, the statutes, and sound mind.
Thank you. Yeah, above our timeline, but I have two questions about your job in university. According to the data on May 2024, you resigned from the position of the managing partner of your own law firm and started as an associate professor, I think, at International European University on a full-time basis job. Can you explain for what reason you decide to change your main place of work during in the May of 2024?
З динаміки моїх отримання виплат заробітної плати можна
From the dynamics of the salary payments, we could see that since the start of the full-scale war, the payments were not regular. So there were periods with active job, but it didn't look like the constant employment. So I decided to apply for the job at the university, and I decided that it would be my main employment, my main activity, and the bureau would be my second job. It can be according to our legislation and according to my logic. If you are paid a salary on a monthly basis, that's what your main employment is. So that was my reasoning.
You noted that you taught disciplines or course like customs, quality management, European integrations, and marketing of procurement activities, and also sustainability of public finance and financial monitoring. Can you explain what kind of experiences you had previously to start teaching those disciplines? They are not so law related, as at least from the names of those courses.
Ще коли я працював
back when I worked in the International Interregional Academy of Personnel Management, I tried to participate in educational activities, and I even passed a minimum score in 3 disciplines, but it happened so that I chose a different path at that time. Also, I had an experience of working in a big realtor corporation, and I provided trainings and seminars for the specialists about the general understanding of the real estate market. And so I trained these specialists in legal aspects for them not only to be intermediaries, but specialists versed in legal area as well. Yes, I don't have a degree or significant experience in teaching, but I wanted to consider whether it made sense to apply for a PhD and to continue on this path. So I participated in the competition. I applied, and yes, some courses were far from my previous experience, but it's something which varies. So I was not teaching every discipline the students could select. Could you please be more concise? Yes, I don't have an extensive experience in these disciplines.
In your written explanations, you noted that you do not personally know the president of the university, Alla Sergeyevna Novolokina, and you are not aware of the information about possible ties between the university management and the Russian Federations. Do you confirm that you know nothing about the background and possible ties between the university management and Russian Federation?
Ну, вона не єдина керівниця.
She's not the only representative of the university management. There are 2 presidents of the university. I do not personally know her. In addition to the presidents, there is a rector, vice rector, chairs of departments, heads of departments. I indicated true information. I do not know her. How can I prove that I don't know something? Before I got the letter from the PCIe, I couldn't even imagine any ties. I looked into her on the internet, and I didn't find a single article about such ties. We can write anything about anyone. I don't think it was ground for me to abandon my activity at the university, should I check every person, every leader of an institution before I apply for a job? It's not wise.
Thank you. And I'm not expert of Ukrainian law, of course, but my question is: does your working place in that university as a lecturer provide some sort of exemption from mobilizations in Ukraine according to the mobilization law?
Yes.
Thank you. Thank you.
Yes, thank you. Yes, you have time passed. I must say that I have a few questions when I read this. And when I listen to my colleague, then I'm wondering what it's all about. The first thing is about this cooperation with the know-how, which was brought into this company. What kind of know-how was that?
I tried to answer to this question in a written format and to answer.
So difficult. What kind of IP rights were they?
Моя частина в цьому ноу-хау, так?
You mean my know-how that I contributed?
Yes, no. What know-how was put in the company, which activated so much capital value? Because I understand you have a company, you bring in know-how, and then the value of the company goes up. That's what you did.
Я можу повторити те, що
I can repeat what I previously said. I can repeat what I wrote. The part that I personally prepared within the project, it was about the use of soil, the water fund regime, because it was planned that there would be a construction on the territory of water fund, and I was useful and I did my contribution. It was a joint activity.
You have knowledge about water and what to do with that. You're a lawyer.
I have knowledge in the legislation which regulates the land of the water fund, but I would like to draw your attention to the fact that I did this analysis 10 years ago in 2016. I do not know anything about ships, but I know the law and how everything has to be regulated.
These schemes, and I've seen many of them in many countries, they are often used either for money laundering, just to bring in money and shift it to a tax haven to avoid taxes or to hide money, or they are often used to legitimize money. That's my experience. What we call them is companies where money comes in and money goes out, either avoiding tax or making money legitimate. That's what it looks like to me. What can you say to that if I say that to you?
Я можу пояснити,
I can say that you first need to have money to transfer them to tax haven, and this company doesn't have the money, and to launder the funds, one needs to have the funds.
But you activate a capital in the company of quite a substantial amount, don't you? Which then is easy to generate losses or whatever.
Реалізація проекту могла би
The project implementation could generate funds, but the company itself was a project structure to organize the implementation of the projects. Actually, if we look at the size of project works on LNG terminal, you will see that the funds are not big. And as far as I remember, the cost of project activities was approximately $250 million. I can be mistaken, but you may correct me.
You know a Lopez Ferreira Pedro André? You know this guy?
Could you repeat, please?
I have a name here called Lopez Ferreira Pedro André. Do you have any idea who that is? No? You know Chris Lucas Sean? Sean.
Звісно, я їх знаю. Просто
Of course I know him. Yes, I heard it. Yeah.
And Peter Leonard? You know him?
Yes, їх знаю. Це молоді.
Yes, I know them. These are young guys. Yeah.
Я їх особисто знаю.
I know them personally.
Costa Mendes. And how did they come to you?
Yes.
How did they come to you?
Я з ними познайомився через свого клієнта.
I met them through my client.
Він попросив надати їм правничу допомогу.
He asked me to provide legal assistance to them. That's how we met, but we knew each other before the start of the full-scale war, and then they left. After that, we haven't stayed in touch.
So you met them all in Ukraine? In person?
Так. В Києві.
Yes, in Kyiv.
Also, Bui Tin Fat Lincoln? Lincoln Bui Tin Fat?
Could you repeat, please?
I have a name here, Bui Tin Fat. Lincoln Bui Tin Fat.
Yes, Lincoln, yeah.
Yeah, Lincoln. What nationality does he have?
Це чоловік.
It's a man, a young man.
В нього взагалі цікаво.
He has an interesting situation.
Наскільки пам'ятаю, він
As far as I remember, he is Austrian.
Паспортом. В нього батьки
His parents have different nationalities, but I may be mistaken. If you give me 1 minute, I will try and find who he was. What was his nationality?
Він німець.
He's German.
Громадянство Німеччини.
Citizen of Germany.
And those men had lots of money to start investing in Ukraine.
Я їх кошти не перевіряв, вибачте.
I didn't check it, what funds they had.
Okay, thank you. Anyone else? Mary? Gabrielle? Jessica? Back to you, Mr. Chair.
Дякую. Я в свою чергу передаю слово Роману
Thank you,
Мартиновичу.
and I am passing the floor to Roman Martinovich. Thank you. My colleagues from the PCIe basically asked all the questions, but I have a few remaining, in particular the ones related to the enterprises that we've been talking about for so long. Some of these legal entities were registered at the apartment, the address of the apartment that you own, but the state register doesn't show any income from the rent of the property. I wasn't providing the rent, but how were the taxes paid from the use of property? The property was not used. Why? Wasn't there a managing body? The managing body was me. That's what I'm saying. That's clear. You mentioned in particular the cash register. Could you recall, according to the instructions of the National Bank, is it possible without an agreement on opening the bank account? Can a cash register of an enterprise exist on its own, or it's being done on the basis of an agreement with a banking institution? I got it. The cash register appears after the encashment agreement is passed. A legal entity can do payments, cashless payments, but there still has to be an agreement with a banking institution. I don't know anything about the specifics. I'm just asking. Yeah, no, I do not agree with this point of view. That's your right. I'm not saying that I'm always right. Again, it's not related to the provision of services of you as a lawyer, as an attorney. The question is to you as the director of this legal entity. We can come across different articles on the internet, on specialist forums, in particular in professional resources, where it's stated that such legal entities that are founded by foreigners are mostly established to get permissions for employment by the foreign citizens to later get permission to reside and get employed in a certain country. Can we state that your companies were established with this purpose? This was related to the question you were asked. So later, these people got permission to work in Ukraine. They announced they wanted to live in Ukraine because they could imagine their business activities in Ukraine and to get permission. Yes, all right, I just confirmed my assumption. Excuse me. I analyzed that at the moment of establishment, the procedure was lawful. I'm not saying it was not. The very question that you asked, no, by no means I am contesting that. Indeed, a legal entity can be established to have working relations, and then it can be grounds to get permission to work. Another question is related to intellectual rights, copyright. You have a lot of patents. Well, a lot, it's an assessment, but you have patents. For example, one of the patents which expires was a patent for management of vehicles with the aerodynamic discharge, then aviation transport system, aviation mobile complex do you spend much time on inventions of such models? I can answer in the same way as to the question on know-how. My father was an inventor, and it was his. These were his inventions, and he just brought the certificates with my surname. Yes, but your father is not in the certificates, and your father is not the owner of other copyrights. He was a founder of a civil society organization. He was a member of an organization. No, he was not a member of any civil society organization. All right, that it was a mistake, but I didn't find any patents to the name of your father. He never registered a patent, but he registered a patent to your name. Was it without your agreement? If he asked for my agreement, I would agree if he explained why he decided so. But I repeat once again that these were results of my father's work, and the invention to stop bloodstream was very useful, and it was invented based on a natural component and doesn't cause the rejection of tissue, and it can be applied to an open wound and save lives. And the Ministry of Defense, it's clear. So you are not related to it. The question was just about your relation. I could call myself an inventor, but it was rather my father. From the point of view of the law, all the patents are no longer active. I haven't indicated them. It's clear. I'm not assessing anything, just clarifying.
The next question is about LLCs, and Norman has asked a lot of questions, just like Robert. Maritime Investment Group and Agricultural LLC. In your statement, you say that it was a big project of yours, and your father also contributed a big chunk of work, and this is your heritage from your father, on one hand. On the other hand, you're saying that you did not control the activities of those legal entities in any way. You did not monitor them. And so if we evaluate these LLCs in the way that you did in your declaration, then it's a significant sum. And how could you be so, how do you neglect so much these LLCs? So it's not about legal perspective. I agree with you completely, just that it's not going to be legal explanation of it. The thing is, my father passed away all of a sudden for us. It just happened out of the blue. We were shocked. And I care about what other people think about me. My father was a very benevolent person, and oftentimes people turned to him for help and advice. And we set up those LLCs together. And then, unfortunately, when he died, I didn't see any of the people with whom we had set up the enterprises. I saw no one of them at the funeral. But of course, everyone is busy. I completely understand it. And then Mykola, the manager, gave me a call soon after, and he asked me to grant him access to the electronic address and access to the cash book. In the first place, it felt bad after all those events that I mentioned and their failure to show up at the funeral. And Mykola, he didn't even ask how my mother was doing. Yeah, so he was only interested in business. He was not only interested, he demanded that I grant him access. He insisted on my doing this. And what did you use to talk? Skype. Then the telephone, my contact list was blocked for a certain time. So let me finish. So the investor was able to invest 200 million hryvnia to build an LG terminal, and the main negotiator used to be your father, from what you're saying at least. And after his sudden death, those relations ceased, and the investor was no longer interested in investing. He not only was no longer interested, he saw he saw that the Ukrainian side was willing and able to move forward. But you said that setting up an LLC was one of the duties on the part of the Ukrainian side. But okay, it happens. This is just one side of the story. The other side, Robert has asked you about it. He asked you whether he asked you that such statutory capitals could be also used to reduce taxation. And under certain circumstances, amortization is used to reduce taxation. Yeah, right. Once capital enters that. And as soon as there is damage, then activities are suspended. But in this case, activities were suspended due to criminal case. Well, we and PCIe understood that activities were suspended due to the opening of a criminal case, and statutory documents were withdrawn, and this is how activities stopped. And this is about like this that you explained it in your statement. So therefore, I'm asking this based on your statement. Well, I could probably finish my thought about my participation there. I never left the LLC until 2025 because I, as an attorney, I was not doubted any minute. I was not suspected of anything wrong. And regarding your exit, you exited the LLC in 2025. In your statement, you say that you bear no grievances. Usually, when shareholder exits the group, they are entitled to compensation, regardless of whether they wish it or not. So the group was supposed to pay you off a certain part of the capital. So the group, the association, holds liability toward you. How come it did not happen in your case? So I guess the balance the association's balance was zero. That was the reason, but I would like to hear it from you. I agree that in case of shareholders exit, they are entitled to compensation, but they also entitled to handle this right. They could gift it or refuse it. Well, you couldn't have any financial grievances until documents were ready. And at the moment of submitting your application, you could not bear any grievances. Yes, I could. So if we go into details, yes, I could bear grievances, but in anyhow, it should be aligned with the documentation. Another question regarding your participation in a political party. Is my understanding correct from your statement that you stayed as a member of a political party until you remained a member? Well, until I submitted my application, to this competition. No, first I ceased my membership and then I applied to the competition. What does your mother do? She's an entrepreneur. Could you give me more details? I will explain why. So you get a loan from her, and your mother's income is significant. Therefore, we would like to know the source of income, of her income. Construction materials, trade, and lease. I think that is it on my side. Thank you, dear colleagues. I will ask a couple of questions that I would like to, then you also can take the floor. So to develop the question that Norman asked you regarding your teaching experience and exemption from military service, when did you show up to become registered? In 2000 or in 1998? The year 2000, 1998. I can hear the date 2004. So as requested by the PCIe, I submitted these documents and I have been registered since the year 2000. Since 24th of February 2022 until you received your military ID until July 2024. Did you update your data? Yes, I did. In May, I already updated. On May 18th, 2024, I updated my data. And when did you get the teaching job? On May 13, I passed the medical examination on my own decision, and I did it from late June until early July, and then I had a leave. So July 11, 2024. No, until May 2024. You did not update your military data and you didn't pass medical examination. Is this correct? Yes, this is correct, because there was no obligation to do it, didn't have a pressing need to do it. Okay, thank you for your reply. In your statement, you indicated that you have no couloir or some hidden connections. Could you explain that? Who does have them? I don't know whose name I can call or I cannot, but as an outside observer, some legal entities, some groups have their representatives in the courts, because this is convenient. That can come in handy. Could you give me more detail? If you know such facts, I don't know such facts. Hold on. You're saying that someone has their lobbyists in courts. So it means that you do have some information about it. Or did it come from the internet? From the internet. Okay, and so you believe the internet and this, even though you did not believe information from the internet when it came to PCIe questions. Mr. Chair, I would like you to understand me properly. I'm not saying that I was a witness in such circumstances. In fact, I'm more like a whistleblower, but there are no circumstances that could testify to my having a bias. I'm impartial here. Okay, then corruption-related cases, embezzlement, whether this circumstance is always a crime? No, only if it is committed by an official. Any other questions, please? A couple questions regarding your teaching experience. So first, you got your job in mid-May, when the schooling year is drawing to a close. And I checked how curriculum was functioning in that university. It may be different, but no, holiday started in June. So which course do you teach? Marketing. No, nothing related to law. How about the Department of Finances and Financial Administration? And how about law-related courses? No courses, and your specialty, according to your degree, is law. So you passed the competition because there were vacancies. How did you learn about competition at that university? Internet and targeted ads. I saw, I think it was on Facebook. It was an ad about international standards in education. Was it an ad about a vacancy? No, it was about education for students. So were you interested in education or in teaching? I just visited that university. I had a look. So we're looking for a university where you could exercise or improve your teaching experiencing. Yeah, I was interested in doing that in my career. And did you start teaching from September? Because there were holidays in between. What did you do in the summer? I was getting ready to teach. That's it, Yaroslav. And next, you could also ask questions. Just two brief questions regarding your practical assignment. Do you remember this assignment? No. I asked to provide me with a text. Okay, then maybe you could call it. One practical task was about failure to declare the comprehensive information. And in part 2, you oblige the offender to correct the declaration within the deadline. Could you cite the norm, the CPC, that requires the court to take necessary steps in this case? I also referred to the law on corruption prevention beyond CPC. because I thought that it would be logical to do that, not only to hold the offender liable.
Чи не вважаєте, що ви таким чином покладаєте на суд повноваження?
In your opinion, are you shifting the responsibility of the financial agency, in this case, anti-corruption agency, to the court? So I decided it like this. And then the second practical task was about criminal offense, Article 396, and you changed the qualification. In which cases the courts can go beyond the qualification proposed by the prosecutor? In cases when it improves the status of the suspect.
Я там так само керувався тим, що жодна особа не може уникнути відповідальності.
My reasoning was that no one can avoid responsibility, liability. In that case, that function was not carried out. Why did you arrive at the conclusion that the charge against the suspect was inappropriate? I will repeat it again. I don't remember all the details, so it's hard for me to answer your question. Just one question to improve my understanding, and if I'm wrong, please correct me. So those LLCs where young foreigners were founders, were you aware of the fact that those LLCs were set up without the aim of engaging in entrepreneurship, but with the aim to have resident certificates for those foreign founders? In fact, they did want to carry out entrepreneurial activities. I knew that they would buy apartments here, etc. Because those people do consulting, and it's not something location bound. They can work from whichever location in the world. But they believed that they wanted to be in Ukraine. That was interesting for them from the point of view of logistics. They enjoyed local cuisine, and they also appreciated local people mindset. When they tried a different country, they didn't like it. So I knew that they meant to become entrepreneurs here. Otherwise, I wouldn't have participated in the same LLC with them. But at the same time, they did not carry out any entrepreneurial activities. It was because of the war, the full-scale invasion, that broke out. But again, the fact is that there were no entrepreneurial activities in those LLCs. Well, I submitted papers to the employment center. We got the work permit. The foreigners entered the country. They assumed their shares in LLC. Isn't it entrepreneurial activities? Well, usually entrepreneurial activities mean to earn income. They were the carriers of income. They invested in this. Ihor, you have already provided answers. We have rules of procedure, and I apologize for interrupting you. Just one more question from Roman. As we studied your dossier, you stated that you changed your teaching position from August 2025. You switched to teaching at a college. Which college was it?
медичний і фармацевтичний коледж.
Medical and Pharmaceutical College. What do you teach there?
Основи
I teach basics of medical law. Which department is it?
Економічне відділення. Там нема кафедри.
Economic department. Okay, so basics of medical law.
А назвати, хто зараз є основним автором у сфері медичного права?
And who is a founder, or what is recommended reading, the author of some recommended reading that you give to your students? In Lviv University, in Kyiv University, in many universities, whose texts do you recommend to your students? Babich. And which work of his? Regarding protocols of medical assistance provision and a medical secret. Thank you. Then no more questions. Then, Ihor, you've got 1 minute to state whatever you wish to state. Thank you to dear members of the PCIe, of the HQCJ. For your time, I try to be honest and address your inquiries. In case I was not comprehensive enough, I would like to have another chance. And I wish you to select the judges based on merit and maneuver in the very hard circumstances. Thank you for your participation.